Good afternoon. I am Janai Nelson, President and Director Counsel of the Legal Defense Fund. I am delighted to welcome you to today's annual SCOTUS Roundup to learn about key civil rights cases from the 2022 U.S. Supreme Court term that ended last month. This term was part of a pivotal era in the court's history, one that was marked by 6-3, meaning 6 dominant extreme conservative majority votes. That was also marked by the presence of the first Black woman Supreme Court Associate Justice and the first criminal defense lawyer since Thurgood Marshall served on the court. LDF was involved as amici or representing parties in some of the most significant cases of this term, and your support helped us litigate these lawsuits, some of which have been active for several years. The court's decisions in these cases do not mean that our work is over in these areas. On the contrary, in many instances, a whole new chapter of our work has just begun. Our collective responses to the Supreme Court's recent decisions will have a direct impact on the trajectory of our future as a democracy. They will determine whether our country will fulfill its potential as a multiracial, multi-ethnic democracy that leverages its diversity to maximize its strength and to provide for the education and well-being of its people. We will determine whether we will honor the personhood and dignity of all people in this country, regardless of their background or who they love. We will determine whether we will allow people to express their will fairly through the ballot, and whether the rule of law will govern our electoral processes. These are the pathways that we will determine the best route to take based on the Supreme Court's decisions and how it has left us with more limited possibilities, but opportunities nonetheless. And the court has made our road much more challenging, but we are willing and ready to face the challenges ahead. And part of our discussion today is to talk about what avenues there are to continue to pursue and advance racial justice. So today we're going to talk about several cases, starting with a voting rights case in which we represented parties and provided argument before the court. While there were some egregious rulings this term, it's important to note that there were also significant victories, and our voting rights case in Allen versus Milligan is one important example, proving that there are wins to be had even in this highly conservative court. Allen versus Milligan is a redistricting case in which the court ruled in favor of expanding the political power of Black voters in Alabama in the face of an indefensible racial gerrymander. We'll also discuss Moore versus Harper, a case that has received a lot of attention in the news leading up to the end of the term. It's another key voting rights case which rejected a dangerous and extremist legal theory called the independent state legislature doctrine. And there again, the Supreme Court ruled in favor of the rule of law. We will unpack that case and that complex theory. Of course, we will also discuss the high-profile affirmative action cases against Harvard and UNC, as well as the student loan forgiveness case. And while the decision in the affirmative action suits was expected, it is still an extraordinary disappointment, given the record that LDF and our civil rights colleagues in the field helped to create, the legal precedent that we stand on, and the compelling advocacy of our team, including our many clients that we represent. By undermining affirmative action, the court has fundamentally rejected the spirit of LDF's seminal case, Brown versus Board of Education, which helped to end legal apartheid in this country. And the court emphasized that it is not as committed as it must be in ensuring that fair educational access is available to all to advance every child and student in this country towards an equal and fair education. As Justice Sotomayor recognized in her dissent, she cited the legacy of Thurgood Marshall and his work in Brown, and she said quite poignantly that the court's recharacterization of Brown is nothing but revisionist history and an affront to the legendary life of Justice Marshall, a great jurist who was a champion of true equal opportunity, not rhetorical flourishes about color blindness. So amid the swirling disinformation and fear-mongering that we've seen since the decision was issued, we will talk about what the holdings in the affirmative action cases mean and what they do not mean. For example, it's very important to note that the court's decision impacts institutions of higher education only. It does not address activities in the workplace, and we will be discussing what some of the limitations of that holding is, and also what the court has laid out in terms of what is still possible in considering race as part of the college application process. What is perhaps most concerning about these affirmative action decisions is the chilling effect that is already happening and how difficult race-conscious admissions will now be going forward, and the impact on the will to continue to commit to DEI programs and initiatives in the workforce. The other big blow to civil rights during the court's term was the decision in 303 Creative versus Elenis on the last day of Pride Month, a time when the calendar is reserved for collective reverence and celebration of our LGBTQ plus community. The Supreme Court undermined basic anti-discrimination principles by holding that business owners who provide creative services, and I put that in air quotes, that they have a First Amendment right to deny public services to same-sex couples. In other words, someone who does not believe in same-sex marriage for religious reasons can deny public services to same-sex couples if those services are considered an expression, an artistic expression of the business owner. The court's decision in that case is truly an abomination, and we will dissect it and try to better understand its reasoning and its application today. While there are other civil rights cases before the court that are certainly worthy of discussion, including a favorable outcome for Native American rights as it concerns adoption, as well as some key cases in the area of criminal justice, we will be focusing on these cases because they are the most salient to the work that LDF does around racial justice, and that we know our supporters are very eager to discuss and dissect. We have an exceptional panel of LDF litigators to help lead this discussion. Samuel Spital, who is LDF's Director of Litigation and General Counsel, Duell Ross, Deputy Director of Litigation and the oralist in the Allen versus Milligan case, and Senior Counsel Michelle Turnage Young. It's my pleasure to turn the presentation over to Duell, and there really could not have been a more equipped lawyer to argue the Allen versus Milligan case before the Supreme Court than Duell, who has spent much of his career fighting for voting rights and education equity across the South, including becoming an expert in the law of Alabama. He's an extraordinary civil rights litigator and one of a handful of Black oralists appearing before the court in recent years. Duell's thoughtful and incisive argument marked the first LDF oral argument before the court since 2016, and we were delighted to see him in action, and even more delighted that his excellent advocacy helped to yield this win. So I will turn it over to Duell to begin our discussion.
Sure, thank you so much, Janai. I appreciate it. So the Allen versus Milligan case, I think, is a significant victory for civil rights advocates across the country. And, you know, it was brought about by LDF's dogged work in Alabama over a number of years, decades even. What the issue was at issue in this case was essentially a challenge that my clients brought, which included Greater Birmingham Ministries and the Alabama NAACP, and a number of really great grassroots activists, including Evan Milligan and Shalila Dowdy, who testified in the case. alleging that Alabama, by drawing, has 7 congressional districts for after the 2020 census. Of those 7 congressional districts, they drew only 1 that was majority Black, even though the Black population in Alabama has continued to grow. It's now about 27% of the state's population, whereas the white population over the last 30 years has only shrunk down, and even in the last decade has gone from down about 5%. So the white people are only about 65% of the state's population. And so the allegations in our case were essentially that Alabama had both intentionally discriminated by failing to draw a second majority Black district, and more importantly, and what we won on was that it violated the discriminatory results provision of Section 2 of the Voting Rights Act. Section 2 of the Voting Rights Act is the general prohibition against racial discrimination in voting. It was amended 40 years ago in 1982 to be solely a discriminatory effects test, and it had been for a long time the part of the system, along with Section 5, that made sure that states with a history of discrimination weren't able to enact new discriminatory laws and also weren't able to backslide. Unfortunately, the court, over the course of particularly the last 15 years, even going back further to the last 30 years, slowly been eroding the protections of Section 2, making it more and more difficult for voters of color to win Section 2 cases, to allege that schemes like Alabama, where Black voters are severely underrepresented in redistricting schemes, challenges to things like at-large elections in which Black voters, undertake all systems in which if Black voters or other voters of color are in the minority, they're not able to elect their candidates of choice. And so this case in Alabama was a really sort of textbook example of vote dilution. You had a region in Alabama, which is called the Black Belt, a series of counties that run through the middle of the state that are, as Chief Justice Roberts wrote in his opinion, many of the people who live there are African American and are people whose ancestors were brought there as enslaved people during the era before slavery ended, because where the Black Belt gets its name is both from the people and from the rich Black soil that exists there, and where those people were brought to work for decades. Unfortunately, it's still a very poor region of the country, but it's also very rich in history. It's where Martin Luther King began his ministry. It's where the Selma to Montgomery March was. It is, it is rich in the people who live there, but it has been sliced up by Alabama for decades into 4 different congressional districts. And what we alleged and showed in our case was that it's possible to draw the Black Belt into 2 majority Black districts in which Black voters would actually have an opportunity to elect their candidates of choice, not just in 1 congressional district, but in 2, bringing them closer to the representation that their numbers would entitle them to in a normal race-neutral process. We won before a 3-judge court in January of 2022. The 3 judges, 2 of whom were appointed by President Trump, 1 of whom was appointed by President Reagan, unanimously said that Alabama's redistricting scheme violated Section 2 of the Voting Rights Act. Unfortunately, the Supreme Court stayed that ruling for 2022, but then we had an argument in the fall in which Alabama essentially argued that the Voting Rights Act is unconstitutional and that any consideration of race in redistricting is also unconstitutional. The court took a long time to issue its ruling, but in June 8th of this year, the Supreme Court, in a 5-justice majority opinion authored by Chief Justice Roberts and joined by Justice Kavanaugh, who had voted to block our win in 2022, he switched sides and voted to uphold the district court's ruling on the merits, found that both that the Voting Rights Act is constitutional as applied to redistricting, which is not something the court had directly upheld in the 40 years in which the Voting Rights Act has existed in its current form. And it also held, obviously, most significantly for our clients, that the Voting Rights Act was violated in this instance for Alabama. And so, as you all may have heard, right now, this week, this moment, Alabama is going through the process of trying to draw a new redistricting scheme. And unfortunately, it doesn't look like the state will do the right thing, but LDF will continue to be in court for our clients, fighting for fair maps, fighting for a map that actually provides Black voters with the representation that they're entitled to under federal law. And I think one other thing that is worth mentioning before I pass it on is that the Voting Rights Act being upheld as constitutional, the Supreme Court for the first time in 15 years finding a violation of the Voting Rights Act is really significant, not just for our clients in Alabama, but our ongoing case in Louisiana, where we're seeking a new majority Black congressional district. Our cases brought by other voters in places like Georgia and North Carolina and Florida, our own cases in Arkansas. So, litigation is ongoing, and having the Supreme Court in a recent case recognize the importance of the Voting Rights Act, that it remains valid, that it remains constitutional, I think will have an impact not just in Alabama, but across the country. And that's because of the incredible work of LDF and our clients.
Well, thank you so much for that informative overview of the Milligan case. I said at the outset that in many ways, our work in various cases has just begun, or certainly is entering a new chapter as a result of the Supreme Court decision. And you just underscored that by pointing to the ways in which the Allen versus Milligan case is creating opportunities in states beyond Alabama to revisit congressional maps and other racially discriminatory redistricting. And so that win is such a powerful one. I want to thank you again for your role in it. One of the things that I hope is not lost in the conversation about Milligan is the fact that Alabama had to vote on racially discriminatory maps as part of the midterm elections. And right now we are fighting against the clock to make sure that we get new maps in place, new maps that are fair and that are lawful and that enable Black voters to exercise their political power in advance of the next election cycle. So there's another important case involving redistricting this past term and a broader threat to voting rights in our electoral processes that emanated from North Carolina. And Duell, I'm hoping you can talk to us about that one as well. That's Moore versus Harper.
Sure, I'm happy to say a little bit about that. So Moore versus Harper was a case in which, as you all probably know, partisan gerrymandering is not, you cannot bring those claims in federal court. But in North Carolina and a number of other states, they have, state courts have ruled that partisan gerrymandering is a claim that you can bring under state constitution and state law. And so what was at issue in this case is essentially the North Carolina Supreme Court last year had ruled that the map drawn by the Republican majority was an unconstitutional partisan gerrymander, and that it diluted the votes of Democrats. And so that case, even it was entirely based on state law, based on the state constitution, but the legislature in the case appealed from that ruling to the United States Supreme Court. And what the basis of that appeal was is that the legislature in North Carolina was essentially saying that under the Elections Clause, the provision of the Constitution that essentially delegates congressional redistricting and other powers to state governments, to state legislatures specifically, that because the Elections Clause says, state legislatures have the authority to draw congressional districts, that state legislatures does not include any aspect of state law. And so essentially that state legislatures are unchecked, that it doesn't, when the Constitution says state legislature, it doesn't mean state court, doesn't mean state Supreme Court, it doesn't mean the governor, even in some extreme interpretations of this theory, and that it only means that the state legislature is the one who gets to decide how districts are drawn. And so the Supreme Court was basically tasked with interpreting whether or not the Constitution sort of keeps state courts or other branches of state government, even state constitutions, from reining in either racially discriminatory voting patterns, partisan gerrymandering. And what was really at issue here was not just obviously the implications for what Congress could and couldn't look like and fair maps from a partisan perspective, but also fundamental rule of law. The Constitution has similar provisions that deal with how electors are chosen for the for presidential elections, where it says, state legislatures have the authority to decide how electors are chosen for president. And so if the court were to adopt an extreme interpretation, it would essentially mean it doesn't matter if your state constitution prohibits partisan gerrymandering or racial discrimination or all sorts of, has any other sort of check on the legislature. What matters is what does a particular legislature vote as a majority on a particular day. And that means that the rules of elections can change from moment to moment. How maps are drawn can change from moment to moment, and none of that could be reined in. Luckily, the Supreme Court ruled in a 6-3 opinion that essentially that legislatures are in the Constitution includes state courts. The one thing I will say as briefly is that there is some concerning language in the Supreme Court's opinion that doesn't fully embrace the idea that it's ultimately up to state courts to make these rulings. But the court also said is it's largely up to state courts, state constitutions to make these decisions. Inclusive, the state legislature is a part of that process. It's not the only part of that process, but that this federal court, if they think that the state legislature overinterprets its own constitution or infringes upon, the Supreme Court's understanding of how courts and the legislature and governors should interact with one another, the court left open the door for it to potentially get involved. But I do think that this is a significant win, and that the court essentially didn't take power both for itself and for state legislatures to decide what is proper interpretation of state law. It largely said that is as we've long understood it for state courts to make those rulings and those decisions.
Thank you, Duell, for unpacking that case with the rather complex legal theory that was at play and the danger that we averted, at least in the near term, in Moore versus Harper. I want to switch gears now and talk about two cases that have captured the attention of both university leaders and students, and also the business community and anyone who is concerned about education equity, especially in higher education. And that is up to our senior counsel, Michele Turnage-Young, to help us navigate the decisions in the Harvard and UNC cases. Michele Turnage-Young has spent her career at LDF working on a range of critical civil rights issues, ranging from education equity to hair discrimination, and she specialized in desegregation cases in the Department of Justice before coming to LDF. She is also part of our team that represents our clients in Harvard, 25 student and alumni organizations, and she helped to co-author the briefs that argued that the court should uphold the settled law around affirmative action that allows universities to consider race as one of many factors, and also helped to lead our amicus strategy, which resulted in a historic 82 corporations signing on to one of the three briefs that were submitted. So Michele, I turn it over to you to walk us through Harvard and UNC.
Thank you, Janai. So as you know, on June 29, 2023, the Supreme Court struck down Harvard's and UNC's race-conscious admissions policies as unconstitutional, reasoning that the policies, however well-intentioned and implemented in good faith, failed to pass constitutional muster under strict scrutiny because they were not narrowly tailored to a compelling government interest. Chief Justice Roberts delivered the opinion in which Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett joined. Justices Sotomayor and Jackson filed dissenting opinions. And I'll note that Justice Jackson recused herself from the Harvard case, given her prior service on the Harvard Board of Overseers. This radical decision comes at a time when when efforts to advance opportunity and education have been under attack across the country, and the need for such programs remains acute. The court's decision is contrary to 45 years of precedent established in prior Supreme Court decisions, including the Bakke case, Grutter, and the cases involving the University of Texas. So how did we get here? SFFA sued Harvard and UNC in 2014. UNC, as many of you know, is the oldest public university in the country. As was the case with earlier challenges to the admissions policies of public universities, SFFA alleged that UNC violated the Equal Protection Clause of the 14th Amendment of the US Constitution by considering race as one of many factors in admissions. Importantly, the Equal Protection Clause applies to state actors like public universities. It does not apply to private actors. The Harvard case is the first challenge to a race-conscious admissions policy involving a private college to reach the Supreme Court. But even though it's a private university, Harvard receives federal funding. So SFFA alleged that Harvard's consideration of race as one of many factors in admissions violated Title VI of the Civil Rights Act of 1964, which prohibits federally funded programs from engaging in racial discrimination. Unlike the UNC case, SFFA also alleged that Harvard engaged in intentional discrimination against Asian American applicants. That claim is novel since in earlier admissions challenges, the claim was that the consideration of race in admissions harmed white applicants. In both cases, SFFA asked that the schools be barred from allowing their admissions officers to become aware of the race of any applicant. So we're going to talk about that a little bit later. In both cases, SFFA asked the court to change the law to ban the consideration of race in admissions. SFFA also alleged that both Harvard and UNC failed to comply with existing law, although for the past 45 years, it had been legally permissible for colleges and universities to consider race as one of many factors in admissions. Now, bear in mind that the Supreme Court held that quotas were impermissible back in 1978 in the Bakke case, so this was never about quotas. Rather, it was about the limited consideration of race as one of 40 factors in the UNC case and one of more than 100 factors in the Harvard case. As many of you know, LDF has been involved in every race-conscious admissions case to ever make it to the Supreme Court. We have also traditionally worked behind the scenes to ensure a robust show of support from a range of influential voices. This time was no different. We helped to coordinate a robust amicus response. About 60 amicus briefs were filed in support of race-conscious admissions in these cases. Those amicus briefs represented more than 2,300 entities, including the 82 major corporations that Janai mentioned. We also represented ourselves and the NAACP as amici curiae in the UNC case, rebutting the misuse of Brown v. Board of Education. And LDF also represents 25 Harvard student and alumni organizations comprised of more than 18,000 Asian American, Black, Latinx, Native American, and white Harvard students and alumni as amici curiae in the Harvard admissions case. And we have represented them since before trial in 2018. So as you likely know, an amicus brief is filed by individuals or entities that are not parties to the case, but have a distinct interest and a perspective on the case that may be helpful to the court. We've been filing amicus briefs in the Harvard case for years now, at least in part in recognition of the fact that we are the only ones representing thousands of current Harvard students. The district court and the First Circuit allowed us to do a little bit more than typical amici. LDF presented members of our client organizations as witnesses at trial and submitted declarations and other evidence. We also gave oral argument both before the trial court and the appellate court. Our clients were remarkably influential in shaping the factual record. Indeed, the district court acknowledged that the amici who testified at trial view their, quote, race as a critical aspect of their life experiences and applications to Harvard, end quote, and that, quote, it is vital that Asian Americans and other racial minorities be able to discuss their racial identities in their applications since, quote, removing considerations of race and ethnicity entirely would deprive applicants, including Asian American applicants, of their right to advocate the value of their unique background, heritage, and perspective, and would likely also deprive Harvard of exceptional students who would be less likely to be admitted without a comprehensive understanding of their background, end quote. The importance of our clients' narrative in that regard has become particularly clear since the Supreme Court opinion has come out. Not only did Justice Sotomayor cite repeatedly to both of our briefs, but the majority explicitly noted that colleges can consider how race has affected a student's life and their ability to contribute to the educational institution in a seeming acknowledgement of our clients' testimony. I'll speak a little bit about the majority opinion, and I'm happy to address any questions during the Q&A period. So as recently as 2016, the court held that the pursuit of the educational benefits of diversity was a compelling government interest that could justify the use of race in college admissions. The court called the pursuit of the educational benefits of diversity, including the interest in equipping students with the skills needed to thrive in the private sector in an increasingly pluralistic society, plainly worthy, commendable goals. However, the court held that Harvard's and UNC's articulated interests in the educational benefits of diversity were insufficiently measurable to justify giving a tip to an applicant based merely on how they checked the box for race. This was the case even though Harvard's and UNC's interest in the educational benefits of diversity were indistinguishable from the interests repeatedly found to be compelling in prior cases. The court also criticized the schools' use of racial categories like Asian American or Hispanic as imprecise and arbitrary. The Supreme Court also held that Harvard's and UNC's race-conscious admissions policies were insufficiently narrowly tailored because the consideration of race negatively impacted white and Asian American applicants, since according to the Supreme Court, college admissions are a zero-sum game wherein a tip for one applicant necessarily disadvantages all other applicants. The Supreme Court felt that the policies likewise failed narrow tailoring because in the court's view, the schools' belief that a person's race could influence their perspective or identity amounted to stereotyping. The Supreme Court additionally held that the policies were not narrowly tailored because they had no endpoint. The schools intended to continue giving a tip for race until they could achieve meaningful representation of underrepresented students without doing so. But in the court's view, seeking meaningful representation of underrepresented students is tantamount to unconstitutional racial balancing, which ensures that, quote, race will always be relevant, end quote, such that, quote, the ultimate goal of eliminating race as a criterion will never be achieved, end quote. But as I mentioned earlier, given our clients' testimony and the line of questioning that Justice Jackson picked up at oral argument about the same thing, the court did declare that nothing in its opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. The court recognized the applicants, what they share about their experiences with race could indicate courage and determination, or that student's unique ability to contribute to the university.
Thank you so much, Michelle. As I said, these cases have gotten so much attention, and there's been such a vast amount of mis and disinformation around what they mean and what is still lawful, that explanation is so critically important for our listeners to understand. And we have been available to answer questions, both formally and informally, stemming from that decision to groups of people, including corporate actors, who want to better understand how they can continue their commitment to DEI and navigate the law. And so we will be continuing to be in discussion with you around those issues. I want to bring in our Director of Litigation, Sam Spital, to talk about another education case that I think is added with the UNC and Harvard cases, painting a fairly bleak picture in the area of higher education, not only in terms of access to it, but the ability to afford it and the future of the next generation of students who will have to carry a debt load that is increasing and increasingly burdensome. So Sam is our Director of Litigation and our General Counsel, and he oversees all of our litigation on each of the issues that you've heard today, as well as our broader dockets on political participation, economic justice, education equity, criminal justice. He also supervises our appellate litigation in the Supreme Court, federal circuit courts, state Supreme Courts, and he is a former Supreme Court clerk. Sam has drafted or contributed to over 50 Supreme Court briefs since joining LDF in 2017, and he is our resident guru on all things Supreme Court. So Sam, I will turn it over to you to talk about Biden versus Nebraska.
Thank you very much, Janai. And let me first just give some shout outs to both Duell and Michelle for the leadership that they provided in the cases that they discussed. You heard that Duell was the lead oralist in the Milligan case, and that was just an incredibly important victory. And for Michelle, I want to just pick up on a note that she made about how in Justice Sotomayor's dissent in those cases, Justice Sotomayor did repeatedly cite the briefs that LDF wrote, including some language that Michelle had really been focusing on, I think, quite regularly throughout these cases, about how the fundamental point at issue in these cases is that talent is distributed across our society generally, but opportunity is not. And the fundamental problem with the court's opinion in those cases is its failure to recognize that point. And I remain hopeful that, and optimistic that someday in our nation's history, hopefully sooner rather than later, those principles will go from dissent to majority opinion. But to turn back to the Biden versus Nebraska case that Janai mentioned just now and talked about in the introduction, this case, as Janai said, concerned the Biden administration's decision to eliminate between $10,000 and $20,000 of federal student loan debt for borrowers with incomes under $125,000 annually. It would have had a huge impact. It would have eliminated student loan debt, which can be crippling for many students, for about half of the borrowers in the country. And it would have been particularly important for borrowers of color who, because of the persisting effects of racial discrimination in all aspects of our society, including, of course, economic life, are more likely to need to turn to federal loans to afford higher education. The Biden administration did so pursuant to a very clear grant of congressional authority in something known as the HEROES Act, which was passed after September 11th, because Congress had a concern about student borrowers and their ability to repay debts when national emergencies have a big impact on the nation's economy. And that law gives the Secretary of Education the power to waive or modify, I'm quoting from the statute, any statutory or regulatory provision applicable to the student financial assistance programs, end quote, that authorized student loans in the first place, when there is a national emergency, such as the national emergency that was declared as a result of the COVID-19 pandemic. Despite this very clear grant of congressional authority, there were a number of folks who were very opposed to the Biden administration's decision to take this step, and 6 states sued to prevent this from happening. They had a problem, though, because federal courts are not supposed to be fora whenever there's any sort of political dispute about a charged question. In fact, they go out of their way, federal courts go out of their way, and the Supreme Court has repeatedly gone out of its way to say, that's not what we're supposed to do. We're supposed to adjudicate very specific cases or controversies, which means that a plaintiff has to have a very specific kind of injury to go to court. And despite their efforts, the states had a very hard time identifying such a specific injury. What they were ultimately able to convince the Supreme Court is that the state of Missouri had standing because of an institution called the Missouri Higher Education Loan Authority, which is a nonprofit corporation that receives fees from servicing federal student loans and would have lost money if the Biden administration's debt relief plan went into place. There was a challenge, though, for Missouri with that argument, or there should have been, because this separate entity, Michaele, as the initials go, was not part of the case. Justice Kagan made this point very powerfully in her dissent. She said, where is Michaele? The answer is as far from the suit as it can manage. It's not a party, it's not an amicus, it's not even a rooting bystander, and in fact have been clear that it was not interested at all in what Missouri was trying to do. Normally, this would have prevented standing because the Supreme Court has repeatedly made clear that when a state creates a separate corporation, a separate entity like Michaele here, that can sue and be sued in its own right, the state should not be able to assert the rights of that separate entity because it's essentially a third party. Nonetheless, the Supreme Court in this case essentially disregarded those principles and allowed Missouri to sue on behalf of this separate entity. Then, once it reached the merits, the Supreme Court said that the Secretary had exceeded his authority under the HEROES Act. Even though there's that very broad grant of authority that I read earlier, it's hard to imagine how Congress could have been any broader in its language. The court invoked something called the major questions doctrine to say that here, Congress needed to do even more. The major questions doctrine is a very controversial and very recent innovation from this court, which essentially stands for the proposition that if the executive branch wants to initiate some sort of regulatory action about something that is major, that involves a lot of people, that involves a significant impact on our nation's economy, Congress has to do something more than just clearly say in the text of a law, here as a grant of authority, but it has to be even extra clear. And as the dissent pointed out, as Justice Kagan pointed out, this doctrine is essentially made up. Well, I'm adding the essentially, she just said made up. And it is particularly problematic because the court has really focused in recent decades on the need to be textualist. They've said over and over, we respect the text of statutes, and when Congress says something, that's what we do. We interpret the text of the statute and no more. And yet, when as here, the text leads to an outcome that the court is not comfortable with because they worry that it gives too much authority to the executive branch to do something like forgive student loans, then the court comes up with the doctrine like the major questions doctrine to not allow the agency to do what Congress has authorized it to do. So the decision overall was to invalidate this very significant program that the Biden administration had created. In response, President Biden issued a statement where he noted, among other things, that his administration plans to look into the possibility of using another law, which may provide an additional source of authority to take a similar action. That law, however, will be much slower. They'll have to go through a much more extensive regulatory process in order to try to see if there's a similar opportunity to forgive these crippling loans.
Thanks for explaining that, Sam. Many of us have heard about the $39 billion that the president has committed to trying to relieve students of in terms of their debt, but it is not, as you point out, the same remedy that they would have received had the court done the right thing in upholding what the Biden administration attempted to do under the HEROES Act. There's one last case that I'm hoping you can walk us through, and it's a significant and pretty devastating one, the 303 Creative versus Elenis case. And it intersects with LDF's historical work on anti-discrimination and public accommodation. So please tell us why this ruling is so disappointing and so very dangerous for many in our community.
Absolutely. So maybe if we start by talking a little bit about the Colorado law in question and the facts, and then we can turn to the issue that Janai raised about just how devastating the case is and how inconsistent it is with precedents that LDF has been advocating for successfully for many decades. Colorado, like many states, has an anti-discrimination law that forbids businesses that are open to the public to discriminate against customers based on a number of protected characteristics, including sexual orientation. In this case, a web designer stated that she wanted to expand her graphic design business in order to begin making wedding websites. But she said that she was worried that if she did that, Colorado could apply its public accommodations law to say that she had to make websites available for same-sex couples, which she opposed. She's opposed to same-sex marriage, and so she did not want to make websites for same-sex couples. And she argued that she had a First Amendment right, a constitutional right, not to provide services to gay couples who wish to get married, even though she's operating a business that is open to the public. And that is the kind of argument that was raised on a number of occasions during the civil rights movement. And the Supreme Court rejected it out of hand unanimously, most notably in a case called Piggy Park, where there was a similar argument raised by a company that was opposed to serving groups of interracial customers, interracial friend groups. And there too, the company said, we have an expressive concern, we are opposed to the message that's going to send. And the Supreme Court unanimously rejected that argument, declaring it almost frivolous. Here, however, the Supreme Court did an about-face. In a 6-3 decision, the court endorsed this argument that the company was making. Even though the website design business that the petitioner was operating is open to the public, the court held that it would be unconstitutional compelled speech in violation of the First Amendment to require that company to do no more than to provide websites available for same-sex couples who wish to get married. Janai raised this critical question about what will the impact of this case be in other cases. And one of the things that is the most troubling about the case is that there is so little reasoning. It is going to fall to the lower courts, including some lower courts who will be wanting to expand the decision as much as possible. The court said on one hand that this decision should not affect most businesses because most businesses are not engaged in the kind of expressive activity that could give rise to that First Amendment kind of a claim. But its analysis was so short, and essentially it just relied on the fact that the parties had conceded in the lower courts that the business here was expressive as the sole basis for its conclusion that there was this First Amendment violation. So the decision just leaves so many unanswered questions about what the next steps will be. But I want to read a little bit from the dissent by Justice Sotomayor, which is so powerful and so dramatically shows that really a line was crossed in this case, and a very dangerous line. And this is what she wrote in her dissent. Today is a sad day in American constitutional law and in the lives of LGBTQ people. The Supreme Court of the United States declares that a particular kind of business, though open to the public, has a constitutional right to refuse members of a protected class. The court does so for the first time in its history. By issuing this new license to discriminate in a case brought by a company that seeks to deny same-sex couples the full and equal treatment of its services, the immediate symbolic effect of the decision is to mark gays and lesbians for second-class status. In this way, the opinion of the court is quite literally a notice that reads, "Some services may be denied to same-sex couples."
Sam, thank you for leaving us on that very sobering note in the 303 Creative case. Justice Sotomayor has been a clarion voice in so many ways and in so many cases, but in this one, I think was so sharp in her analysis about where this leaves us. We have roughly 10 minutes to answer questions. So again, I invite our audience members to use the Q&A function and send us anything you'd like to see us address. I'll start with the first three, and I'm going to do them all at once so that we can move as quickly as possible through questions. The first one is for you, Michaele, and it is a question about what corporations, foundations, universities, and other entities can do in the wake of Harvard and UNC, what they are still permitted to do, what actions they should take in direct response. The second question, Duell, is for you, and it is, what does the Allen versus Milligan case mean for states outside of Alabama? You talked a little bit about the work that we're doing in Louisiana, but are there other implications that we should be aware of? And then, Sam, there is a question about what LDF is doing to prepare for SCOTUS next term, and is there anything that we should be aware of and have on our radars? So why don't we go in that order? Michaele?
Thank you so much for that question. There is so much that business entities and others can still do. First, for our business community, please consider signing on to the open letter from the business community in support of diversity in higher education that some of your colleagues have put together. If you do not have a link to the letter, we can provide that after the webinar. Also, please publicly reiterate your commitment to advancing equal opportunity and engaging in diversity, equity, inclusion, and accessibility programs. I will note that as the chair of the Equal Employment Opportunity Commission explained, the Supreme Court's decision in the Harvard and UNC cases, quote, does not address employer efforts to foster diverse and inclusive workplaces or to engage the talents of all qualified workers, regardless of their background. It remains lawful for employers to implement diversity, equity, inclusion, and accessibility programs that seek to ensure workers of all backgrounds are afforded equal opportunity in the workplace. So in addition to doing those things, I encourage companies to understand that they're still obligated to comply with federal and state anti-discrimination laws. So it becomes incumbent upon companies to take a hard look at your outreach, hiring, and promotion criteria to make sure that you're not inadvertently excluding talented candidates from certain communities by preferring credentials that simply aren't equally accessible to everyone. Consider taking a broader expanding your applicant pool, look at a broader range of individuals as candidates. And, just be mindful about how your company is communicating about programs that further equal opportunity.
Thank you. That's just a reminder. The question was, how does the Allen versus Milligan ruling impact people who live outside of Alabama? So as I mentioned, and Janai noted, LDF has a pending case in Louisiana where we're challenging the fact that Louisiana also only has one majority Black congressional district, and we're seeking representation and an equal opportunity for Black voters in a second district in Louisiana. That case had already made its way through the trial court and through the Court of Appeals, and actually was also put on hold in the Supreme Court. Now the Supreme Court, in a per curiam decision, has allowed that Louisiana case to go forward. And so our hope and expectation and the court's instruction was that our clients can get relief before the 2024 elections and hopefully have another Black district in Louisiana. In Arkansas, LDF also has a pending case challenging racially discriminatory Court of Appeals maps there, and also racially discriminatory at-large elections for the Supreme Court justices. And so that case is in, waiting for the trial court to issue a decision for a number of months. And so our hope is that with this decision in Allen versus Milligan, that we'll have a ruling that will allow for more representation for Black voters in Arkansas as well. And there are a number of cases that LDF is not directly involved with, like challenges to congressional districts in Georgia, challenges to state legislative districts in places in Georgia, Arkansas, and other places. And so our expectation is that given the strong record that we're aware of in a number of these states, that this will directly lead to more representation for Black voters across the country. One other thing that I think is really important to highlight, well, two other things. One is that now the courts just affirming the constitutionality of the Voting Rights Act, affirming that the use of race is constitutional in redistricting when you're trying to remedy Voting Rights Act violations, sort of stems the tide of what we've seen over the last, as I said, 10 to 15 years from the Supreme Court, where they've issued rulings like Shelby County and Brnovich, which have weakened the Voting Rights Act. Here's a strong opinion from a 5-justice majority saying you can and should continue to enforce the act. And the last thing I'll say is, sort of the opposite, that if the Supreme Court had adopted Alabama's arguments, we would have seen a real erosion of the rights of African Americans. And so just the fact that the court has pushed back against that erosion of Black voters' rights, at least in this context, is really important, particularly given where the court has been in nearly every other area related to civil rights of Black people and other people who are marginalized across the country.
And in terms of next term, we are going to be back in the Supreme Court with our colleague Leah Aden, Senior Counsel at LDF, presenting oral argument on October 11th in yet another major congressional redistricting case, this one out of South Carolina, where again, we won before a 3-judge district court, recognizing the state had implemented an unlawful racial gerrymander that discriminated against Black voters. This one is a little bit different than Allen versus Milligan and some of the other cases Duell was talking about, because it arises directly under the Constitution rather than Section 2 of the Voting Rights Act. And that's because, at least as interpreted by the Supreme Court, Section 2 in the redistricting context generally requires plaintiffs to be able to show that they could have drawn, the government could have drawn an additional majority Black district or majority people of color district. And in the case that we have in South Carolina, that would not have been possible. But instead, we have a direct constitutional claim that what essentially the state did was they were focused on keeping the percentage of Black voters in one congressional district to a fixed target because they were concerned about the ability of Black voters to have more influence in that district. And in order to do so, the state did all sorts of things where they created very funny looking lines. They cracked communities of interest, and district court recognized that those are the kinds of things that are unconstitutional under the 14th and 15th Amendments. The state appealed, and because of the nature of this case, there is no intermediate appellate court, so it goes straight to the Supreme Court. So we will be arguing that case next term. I think the other sort of kinds of cases that we may see going to the court, although there's none that the court has decided to review yet are cases that will sort of further flesh out some of the principles we've been talking about today. So we know that one of the next challenges that we're going to see in terms of the racial diversity in education space are challenges to race-neutral policies that are designed to achieve racial diversity. And we got an encouraging signal from the court recently in one of those cases that arose out of the Fourth Circuit, where the Fourth Circuit had sustained in an intermediate part of the case, had upheld essentially a race-neutral program that achieves racial diversity or seeks to achieve racial diversity. And there was a challenge to the Supreme Court that the court declined, at least in an emergency posture, 6-3. But I think we expect to see more challenges like that, both next year and then into the future.
Thanks, Sam, and thank you. Those were excellent questions. As you know, LDF has been active before the Supreme Court for our entire 83-year existence, and we are not relenting now, even though this Supreme Court seems steadfast in its assault on civil and human rights. We also intend to use every possible win that we get from the court, as we did in Allen versus Milligan, to extend the principles and the potential impact of those decisions to benefit the communities that we serve and to advance racial justice and constitutional principles in every possible way. And we are grateful for the support of this group, all of you who helped to make that work possible and fuel the work that we do. As you heard today, we are centered in that work. We had an amazing oralist this term. We will have another one this upcoming term. We will continue to coordinate amicus strategy. We will continue to lean in and do all that we can to maximize what we can extract from this Supreme Court and to make sure that we are continuing to shape the doctrine that may eventually come out of some of the dissenting opinions in a future court. But we are not giving up on this fight and giving up on this important forum to advance justice in the way that we have for over 8 decades. So I want to thank Sam and Michelle and Duell for sharing their insights and their expertise with us today, and for all the work that they and so many of our staff do in all of our federal courts and our state courts. It is a critically important work. And as I said, we will remain steadfast. I also encourage you to visit our website, and in particular, the website of LDF's Thurgood Marshall Institute, where we have a summary of other cases, in addition to the ones that we talked about today, that were important and bear on racial justice issues this past term. So you can find synopses of those cases and other information that would be useful to you on our website, our Thurgood Marshall Institute website. Thank you so much for joining us.